Hi, welcome to mediatorpodcast.com, a podcast and video series about mediation, negotiation, and collaboration. My name is Melissa Gragg, and I'm a valuation expert and divorce financial mediator in St. Louis, Missouri. I specialize in divorce and partner disputes, and today we're going to be talking about business disputes. And Margeaux Thomas has worked with entrepreneurs and small business owners, specializing in commercial, landlord, tenant disputes, business partnership disputes, contract disputes, franchises, partner issues, non-competes, non-solicitation. She's actually located in the DC area. And today we're going to talk about moving from arbitration to mediation in business disputes. Welcome, Margeaux. How are you?
I'm doing good. Thank you for having me, Melissa.
Awesome. Okay, so I specialize mostly in divorces and business disputes where there is a valuation involved. And what we're going to talk about today is really the fact that there's a ton of areas that are really ripe for maybe mediation in a business issue, that business owners are just defaulting to arbitration or have contractual language around some of these issues. And I think that what we want here is a perspective to walk away after today with a perspective of how a business owner could use mediation or these alternatives to get through some of their daily issues with suppliers, vendors, and really in some situations where you may not want to sue somebody that you're working with, but you have to come to an agreement. And quite frankly, when we first started talking about this with Margeaux, I really didn't know what types of business issues she is seeing, being on the East Coast, kind of having your whole practice around this. What types of issues are you seeing come through mediation that involve businesses?
So we have seen just about every kind of issue go through mediation, but I think that the issue that is best suited for mediation is what we call business divorces. Business partners who are going their separate ways for one reason or another. And the reason that I think that those are so well suited for mediation is because there is a money aspect, there is a valuation aspect in every single one of those, but there's also underlying issues that also need to be resolved in most of those cases. It is not like having a dispute with a supplier or a third party who you can just end the contract and go get another supplier. You never have to see this person again. When you're dealing with a business partnership dispute, most of the people that we deal with are siblings, they're family members, their husband and wife, their cousins. They've known each other for 20 years. That's why they went into business together. A lot of them do not have a lot of they didn't hire a lawyer at the beginning to get an operating agreement or some type of foundational document because they know, love, or trust the other person that they're in partnership with, which makes the mediation a good avenue to try to work through a resolution because there are a lot of emotional factors that play. There's other family members who may not be in the room who may have an influence on that outcome. There may be things other than money. Who is going to continue to run the business? What is the person who is going to walk away from the business going to do? What are they going to focus their efforts on? There's a lot of intangible things that need to be addressed in resolving the business partnership dispute. And a lot of those things can be addressed in mediation much better than they can in a courtroom. Because in a courtroom, they're going to say, let's sell the business. Let's break it up. Let's sell it to somebody. Let's split the proceeds and you go on your separate ways. And that doesn't address all of those intangibles.
Well, and I think that, one of the things that, when we were first talking, whenever I first came on even the podcast, I typically deal with divorces, and divorces are going to be two people kind of separating. Now, you said a term which we actually use very regularly, right, in business, and this business divorce. And and I think you've kind of talked about it in general, but there is, this is normally going to be what we think as a regular partner dispute where you either have multiple partners and you're buying one in or out, you're going apart, but you could also be coming together. Like you could be pulling things together as well. So in a business divorce, which is kind of a term that, is loosely used, right? We're really talking about all aspects, like if they own property, right? If they have land together, if they have business contracts together. Like this is also like your firm also deals with a lot of the legal aspects. Like it's not just a financial aspect, but it's the unwinding as well and negotiating, because not always do they have money. Like, and then somebody's wanting to be left, well, I want the website. Well, I want the logos, the name, and things like that. So talk to us a little bit more about, how you're seeing people kind of in this space.
Yeah, I think it's a very difficult situation to deal with because, like I said before, it's someone that you've known for a long time, and now you're at an impasse. And that impasse usually results from some type of communication issue. You have differences on how the business should go forward. You have differences on how much you put in versus the other party. You don't value their contributions as much as your own. We have theft issues. I mean, there anything under the sun we have seen when it comes to a business divorce. There are all types of reasons why people are at this impasse, but I can say that a lot of the times it comes down to expectations and communication, and there's some malalignment there with those. So, and I think you hit on a key point. I mean, it's not just about the business being separated, but a lot of those businesses own real estate, and that needs to be there are loans associated with that. There are guarantees associated with that. People's credit is tied into that. So there's a lot of unwinding that needs to be done. And there's cases that involve IP, there's products, there's trademarks, it touches on a lot of different areas of law, depending on the type of business. And the issues tend to be the same, but they can relate to whatever type of business people are in. I mean, we've done hyperbaric chambers to dental offices, to doctors, to lawyers, to law firms. I mean, there's a lot of intricacies to being in a situation where one or more people need to go their separate ways, and the businesses have been successful. So there's something to break up. And a lot of people feel very close to, it's almost like having another child to the business that they built from nothing and has now turned out to be very successful. So they have an attachment to the business that makes it very difficult to get past this or overcome the impasse and walk away or take over something that they haven't never run in this capacity before.
Well, and one of the things that I think we'll talk about are some of the benefits that we see in mediation. But one of the benefits I wonder, and you would know more than I would, is when you're getting into these mediations and you have two partners coming in, and now they're actually communicating. Now they're actually talking about at least what they're going to do to separate. Do you ever see them come back together? Like it's like the mediation kind of jump started them to go back together, or for the most part, are they ending that relationship?
People do not come to our firm until it's the last straw. In 99% of the situation, if they could work it out and we're going to get past this and move forward, they would not be knocking on our door.
Okay.
And mediation does not mean that they're not in litigation. We have most of our cases, there has been litigation filed, and they're at a point in the lawsuit where they want to pursue what we call alternative dispute resolution, a way to resolve the litigation while it's going on. So there may be motions being filed, the case is going forward, but the parties have voluntarily agreed to engage in the mediation process and go meet with a third party to try to resolve it. So there's usually a lot at stake. And it's somewhat sad when you think about it, because a lot of these people, we've had one case in particular was a grandmother and her grandson, and they were in a very contentious dispute that ended up going to trial and getting appealed and went along for many years, and they never spoke again. And they were family members. I mean, she had raised this child as her own child, and they never spoke again. So there are a lot of people who this is not something that is going to, be unicorns and rainbows. They're going to work through it. I mean, that's not where they're at in this process. The business is going to be separated one way or another. The parties want freedom from each other. It's not that type of situation. Unfortunately, that's not really what we see.
Yeah. And I think that what we have seen is that, because I would say for the most part, most people start in litigation and then they kind of are like, there's got to be some other options. So we move towards mediation, even as a professional, right? But also in general, like when you're running a process, I feel like you can run both of them. Like you can have your litigation process kind of working in the background to keep your deadlines and keep everybody moving forward. But the reality is that most states, most jurisdictions, are starting more in the family law arena, but I think are going into a lot of other issues that they're requiring mediation at the beginning of a situation. Like at least do 2 to 4 hours with somebody in order to see if you can figure this out, because you have more control. And control is one of the benefits of mediation. But talk more about that, because I think that people say, "Oh, you have more control over the situation." That's not really true. You have more control over the input into a solution, but where does some of the benefits, like your favorite benefits of mine are control and privacy and confidentiality, I think are big issues that I see benefits for mediation. What are some of yours?
I think the biggest benefit is time. I think that
Mm.
people undervalue the emotional investment that goes into being involved in litigation. I mean, they're up at night thinking about it. There's anxiety involved in that. And most of these people are still running a business. So the emotional energy that you are taking out of your business and devoting to this dispute can't be replaced. So I think that that means a lot. And being able to put this behind you and move forward without this hanging over your head, I think makes you a more productive business owner. And, I see people who are tied up in litigation for years and you can't get that time back. And there are a lot of, what is the word? I would just say that they're giving a lot to the process. And I think that
Mm.
people just don't see how much, time and energy and thought and, that they are dedicating to meeting with their attorneys and coming up with the next motion and strategy and discovery. Just the word discovery. When you need to produce documents, years of documents of finances and what every dollar that has come in or gone out of the business and how this was a business expense and how the taxes were. I mean, the scope of discovery in court these days is very expensive, and the amount of time that clients spend compiling that information and being involved in discovery disputes about pieces of paper that were lost or weren't given or redacted or whatever the case may be, I mean, just takes a lot out of people. And I think that that is one of the biggest benefits of mediation. If we can meet over a couple of days with a third party and reach a resolution that will put this entire matter behind you forever, I mean, that is a huge advantage. But I think there's also a lot to be said about the types of resolutions. There's flexibility in mediation that, the court, in most of the cases that go to court, there's what's called a receiver that is appointed. It's basically kind of like a judge, but usually an attorney, and they get involved in how the business is going to be split up. They can bring an evaluator, they can bring in a forensic accountant, they can look at the finances, they can, depose parties, they can go to the facilities to see how the business is run, but they're basically going to figure out, how do we sell this business for pieces and separate the money between the people. It's a very expensive process. It's a time-consuming process, and most of the time, the business owners have a very good awareness of what they need to get out of this to walk away, and what the bottom line is, or what the best and final proposal they would take, and they can do that without having a third party impose that resolution on them. A lot of the resolutions that are reached between the parties in a mediation are more favorable, in my opinion, because there is some buy-in by the business owners themselves.
Well, and I think that all of those points like I could belabor all of them because I think that those are all important. The emotional attachment, I think, is a big deal. I think it also is some of the components of what would prevent a mediation from being hyper successful if you have just people that are so locked in and can't see any other options. But you're right, at that point that they're coming to you, they've tried all of the other options. They've looked at other options, and a lot of times people are looking, or a lot of contracts that I have the benefit of looking at a million contracts a day with business owners, operating agreements, shareholder agreements. And most of them, anytime you sign anything to purchase something, or, it's always got a clause of, even my contracts, like, you can't take me to court, but you can take me to arbitration in the state of Missouri and things like that. Are, how, you know, arbitration and mediation kind of originated as legal concepts, if you will. They kind of like fell from the legal system. So tell us more kind of from that framework. Like, have you seen people shift from arbitration to mediation, or is that still the first place? Like, if you have a multi-million dollar business divorce, like a $50 million, even a $1 million, like, are you seeing people still go that route of arbitration, and what does that look like? Or are you seeing them shift just straight to mediation because there's maybe less barricades involved in it?
So I think that for a long time, arbitration was just the go-to. Business attorneys would put an arbitration clause in just about every operating agreement or other contract, and it said that the parties agree to binding arbitration, and it was either with AAA or JAMS, and there would be maybe a panel of a couple arbitrators, and that's how this dispute was going to be resolved. I think there has been a shift to take arbitration clauses out of contracts because it is an extremely expensive process. And I'm not sure a lot of people appreciate the nuances or differences between arbitration and mediation. But basically, arbitration is binding. It's like going to court. There's going to be a person who says, you're right or you're wrong, or you owe this much money, or this is how we're going to resolve this, and you are bound by it. And there's usually very little appeal opportunities after they come up with an outcome, which means that if they come up with the wrong outcome, or they don't, review the facts, there's not much you can do about it, which is, I guess, good to some people. I mean, if you're winning, but there are people who judges have bad days and they make mistakes, and arbitration can be a difficult process because there aren't a lot of options if you are on the short end of that stick and do not get the outcome that you want. But it's also very expensive because when people go to court, your tax dollars are usually paying the judge's salary. But in arbitration, you're paying an hourly rate for the judge, and the judge is usually very expensive. So, and that judge is going to be involved in every aspect of the case. So every motion, every discovery dispute, the scheduling order. And then there's also this administrative body that helps facilitate arbitrations that you have to pay for as well. And there's like an arbitration coordinator on every case that just makes sure that things flow smoothly and everybody gets the information you need. You pay for them too. So it becomes very, very expensive. There's a sliding scale based upon how much is in dispute of how much you even have to pay to initiate an arbitration. So you could have to pay $5,000 to even get into arbitration, whereas the filing fee for a federal court complaint in Virginia is like $400. So it is a huge difference in the amount of money that is spent in arbitration. So I think that there has been some shift in understanding of the disadvantages of arbitration. So people are leaning away from that. And mediation is a voluntary process. There's nobody is going to come in and say, you have to do this. You're not going to be bound by it. You have to reach an agreement that you are okay with. Both sides have to sign on the dotted line. The mediator has no ability to force an outcome on any of the parties. And that's why the parties need to be involved in that in good faith. They want to have to be there. I mean, they need to be there wanting to reach a resolution and put this behind them. If one of the parties is not and has some ill motive, then it is not going to be successful. But so a lot of agreements we see now, especially operating agreements, say that before you can go to court and file your lawsuit, having anything to do with the business or your business partner or whatever your dispute is, you need to try to mediate the issue. And I think that is, it's called a precondition before you can file your lawsuit. So you have to check this box. And some people would say forcing people into a voluntary process is not a great idea, because if they're not really doing it because they want to be there, how successful is it going to be? But in my experience, it has been very successful, because a lot of people don't want to be engaged in litigation, no matter how much they hate their business partner or want to be away from them. They usually do go into mediation with good intentions and good faith. And we have had experiences with a lot of very good mediators who can get to the brass tacks of the situation and figure out, what are the real motivating factors here, and save the parties a lot of time and expense before a lawsuit is filed. So I would say that compared to 10 or 15 years ago, the number of mediation clauses that I see in operating agreements has increased tenfold.
Well, I think that mediation clause that you just said, or even anything, is way more brilliant than just forcing to arbitration. Because, and I can only say from a perspective of understand, like I do a lot of business divorces, but I do a lot more individual divorces. And we also have collaborative divorce where you're signing an agreement and you're going to be a part of it. And with arbitration, you're signing an agreement and you're going to agree that you're bound by those decisions. The problem is, in some capacity, is that we as humans want control over what we're going to have to be a part of. And like you said it, I think you said it earlier, is the buy-in. If you don't have both sides saying, hey, we're probably going to have to come to an agreement that's not the best for either one of us, right? But we're going to have to get out of it. I think that for the most part, people don't want to be bound to a system, be it court, be it arbitration, be it any system that requires them to take spoon-fed what a third party is going to say about that dispute. And that's how mediation is also different from some of those, is that yes, nothing's going to bind you to do it, but also the fact that, it's like even working with kids, like if both of them come up with the solution, the odds are they're going to champion that solution to the end. And there are steps. You're going to have to like change the, like all of these things that take additional time that aren't solved. And like even in the arbitration, they would just say, okay, great, split this and you keep this and you keep that. Then you have to go for months and unwind those things legally. Whereas if you go to the right, and this is one of the things that maybe we could talk about a little bit, but it really does mean that you need to go to the right mediator. And I think that everybody in business or in the world thinks that mediation is like the same thing, like it's just like, and it's in a black box. So I really don't know what it is, but I know it's all the same. The reality is it's very different for all of these purposes. I mean, you even have like people who are just doing labor disputes, people who are just doing landlord tenant disputes. Like you really have to find the right connection. But as a business owner, like if we're not getting along, and maybe it doesn't have to be to the point of like, I hate you and I don't want to be partners with you, but like, we just need to go our separate ways. We have two great ideas for the future. We totally don't get along, but that conversation is uncomfortable because we're friends. Our families hang out together. We don't want to ruin this relationship. A lot of times this is to prevent the ruining of that relationship, because you have the mediator that's asking those hard questions, right? But in general, what do you think a business owner would need to do to even consider? Because I want to step back, like, hey, you and we're just not jiving like we were, and we've been partners for a long time. We have some stuff to separate. We think we could do it, but we don't know if it's fair. We don't know if it's reasonable. Then what would they first do? Do they need to first contact you, one of them or both of them? Like, how do they even get ready for this process and have it be very transparent?
So I think the process is the most productive when there is sufficient preparation. And I have a athletic background, so it's similar to just, you wouldn't go and join a basketball team and show up for the first game without learning the rules, talking to the coach, going to a practice. And some people just feel like I'm just going to show up and whatever happens, happens. And I do not agree that that is going to be a very productive way to, I mean, there's a lot of preparation that goes in, and there's a lot, kind of like therapy. I mean, you really need to think about what it is that you need to get out of this. Like so the legal or negotiation terms for this are BOTNA and WATNA, right? What is your no deal option? If I do not reach a resolution at this mediation, what's the worst thing that's going to happen? Or what is the best thing that's going to happen? Because you need to have some parameters walking into it about, this is a good deal because this could happen if I don't take this deal. And if you do not think through those scenarios and try to figure that out before you step in the room, how do you know that the deal that you agree to is a good one? And it also leads to buyer's remorse because you wake up the next day and say, why did I agree to that? I mean, there's a lot of pressure to an extent. I mean, you may be in a unfamiliar environment. I mean, there's a lot more virtual mediations now, but there are also a lot of in-person mediations where you're in a room that you've never been in for a very long amount of time. Whether you have dinner on time, whether you've been there 12 hours, you're getting tired. There's all kind of like environmental elements that are at play. And to the extent that you are very clear on what it is you need to walk away with for this to be a good deal, I mean, that needs to be set in stone before you walk into the room. And I've just seen too many people or lawyers will just figure it out. This is not the situation where you get there and try to figure it out. Just like any sport, like this is not where you just, jump in the pool and say, I'm going to swim a 500-meter race. This is not that. There's a lot of preparation that goes into just thinking about those scenarios and calculating. And that may be a math calculation. What is the business worth? Let's look at the numbers. How much do I need to walk away with to feel like, I got, what I deserve in this situation. A lot goes into picking the mediator. I say a lot. Just because it's a good attorney does not make them a good mediator. Just because they're a good judge does not make them a good mediator. A mediator has a specific set of qualifications that I think make them really good. There are two things that they have to be able to do, and there's two hats, I should say, that they have to be able to wear. One is a facilitator of information, and the other is an evaluator of information. And they have to switch between these two things at the right time during the mediation. So there are points in the mediation where they need to say, look, you have a bad, your case is not that good. Like that is not going to be that persuasive, or, your credibility on that issue is not the best because of these other things that you've done that kind of conflict with what you're saying right now. And they need to be able to do that in a way without making the person feel bad, right? They cannot beat up on the person and then expect them to, engage in this voluntary process and really get the outcome that they want. So I think that really good mediators have a way of delicately saying that, but allowing the person in the room to understand what they're saying, right? And there are people who just want to force information down their throat or say, look, if you go to court, you're going to lose. Like that's not the way to get people to buy in to the solution that they need. And I think that good mediators recognize that. And they're very good at allowing people to feel heard, but also evaluating the merits of what their position is in a neutral way. So the person doesn't feel like they're taking sides or against them, but moving the parties to a solution. I mean, the mediator is going to have to go into one side or the other and say, look, your portion is not worth what you think it is. Like that's an inevitable conclusion, because in every business divorce we handle, it's called the IKEA effect. If you build something from IKEA, you feel like it's worth more than what you bought it for because you put your hard-earned, work and effort into doing it. You just feel like it's worth more. Now you have a story to tell about it. I was like putting this together all night. Like now it's worth more. It's the same thing with the business. Like you put your sweat and tears and time into this business. Even if you are 50-50 partners, inevitably one partner is going to believe that their portion is worth more. And that's just human nature, because you feel like the other person isn't doing half as much as you are, right? But the mediator has to be able to come in and say, look, but this is a mathematical, we can look at time, we can look at, how much the business is worth, we can look at, what your roles are. I mean, there is a way to logically figure out exactly what your portion is worth. And some people do not want to hear what that is. So I think that a good mediator is able to communicate that information in a way that the person does not feel defensive or attacked or, like, I think that that's the key. So I think that that is more important than the mediator having a wealth of knowledge in the area. It could, you could have some very complicated IP dispute, and yes, the mediator could have like 20 years of education and, mediated all types of disputes, or been a judge that just specifically did trademarks for, decades. But that is not the skill that I think is the most important when choosing a mediator. So in preparation for a mediation, I like to reach out to other people who have used that mediator, or preferably use a mediator that we already have used, that we know that is going to be very good, and ask that question. And it's not about what the mediator's resume is; it's about what are their statistics on resolution. And I think that that goes a long way. There are mediators, 95% of the time they reach a resolution, and that's not because they know the ins and outs of every practice area and issue that comes before them. So so I would say the big things in sum are the mediator, selecting a mediator that is going to be good, that has some knowledge about the practice area, but really is a persuasive individual that is able to wear those hats at the right times. Thinking about the best case and the worst case. I think environment is important. If there's a way that we can do it, I say home court advantage, let's do that. So I offer up my office to the extent we can. Let's have it here so the client can, they've seen it, they've been there. That plays a lot into, success and people's comfort levels. So virtual can be preferred, where people can be at home and in their own element. So that's important. I think those are the big ones. There's a lot goes into preparation though. So
Well, and I
all of
think
those
that
things kind of go to preparation.
when I ask somebody, like I'll say, "Oh, did you prepare for that mediation?" And they'll be like, "No." And I'm like, "Okay, well then in those cases where I know the other side has not prepared, like I will always win. I will always get over in some capacity because you don't know the numbers. And you're making decisions in real time, which is hard for some people, So if it's hard for you to make a decision in real time, you practice the decisions beforehand. You say, "Okay, what would I say?" Because it's really like, would I say yes to that or would I say no to that? And you have to be clear. Like sometimes you don't know what you'd say yes to, but you know what you would say no to. And even having that understanding. But one thing that I think that people get a little confused that you can maybe fix a little bit is that I think one of the reasons why they don't prepare for mediation is because they think they're going into the mediation and the mediator is going to save the day, come up with the perfect solution, and tell them what to do like it is a judge. And so they're kind of like, well, I mean, they know what to do. I don't, I'm just there for the ride. Like I think that that is a huge misconception. And that if you're not planning ahead, if you're not preparing, if you're and quite frankly, there might be other people. Like you could go into mediation and you could have your own valuation person. You could have your own IP, expert. You could have or these people might already be in your company. Like you might be just talking about these things and getting feedback from the mediator, but the mediator kind of gives you a view of what somebody is going to look at from the outside of the situation and give you an honest opinion. But don't you think that a lot of people come into mediation planning like, okay, well, what's your solution kind of situation?
I think so. And as an attorney, from my vantage point, there should be nothing that the mediator says during this mediation that you haven't heard, right? But there are situations where I know that the opposing counsel has not told their client a huge issue with their case, or has not conveyed it to them in the way that they need it to be conveyed, right? And so my job is to come in and convince the mediator of how big a weakness this is to their case, and to get the mediator to go into the other room and say something to the other person's client that they have not heard or haven't heard in that way, right? So I think a lot of people also think, well, it's just neutral and they're just moving information back and forth and they're just shuttling stuff. And no, we want most of the mediator's time to be in the other room, trying to get them to come to the number or whatever the solution is that there's going to be some compromise for sure, but we want to know what that realm of compromise is, and we want to be prepared. I will go into a mediation and say, look, we know this is our weakness. I will say that to the mediator. You do not need to tell my client the weakness. We know what the weakness is, but this is what we need them to focus on. And I think that mediators appreciate that, because they're not going to spend 25 minutes telling my client that this is a weakness. We know, but we need to focus on these things to get to this number. And I think that people, I don't know why, will just we'll see what happens attitude. And I think that is a losing proposition. So if you have a lawyer who just says, all right, well, we're just going to show up and see what happens. If it doesn't settle, we'll just go to trial and, we'll just keep it moving. Then I don't think that they're really, giving mediation the time and energy that would make it effective.
Well, and I think you've already even talked about one strategy of how to use, mediation to your advantage. I think the preparation is a piece of it. It gets you very clear. I typically tell people that the mediator is not your therapist. You should not tell them everything, that you should really be telling them your best version of the story in order for them to take that to the other side and be like, okay, well, here's where they're coming from, right? I also, like, one of my little fun things is I create kind of a cheat sheet that I'm more than willing to be, like sometimes mediators will request information. Maybe you can talk a little bit about that a lot of times mediators will want some information up front. So you would need to be prepared for this. But also having your own cheat sheet so that you stay focused, you stay, concerned about the big points in mediation, and you're not getting all distracted by all the minutia, right? Which could take time. Like if you have to describe an event that happened 5 years ago and it takes a half an hour to tell the story, you're losing some time where you could talk about the really big issues. So what are some other strategies that you think, and can you gain an advantage? Like, should you be manipulating the system and things like that? So what are some of your super tricks?
So before the mediation starts, there's usually a meeting with the attorneys and the mediator to discuss the framework of the mediation. And at that meeting, the mediator sets a deadline for the parties to submit a statement. And that statement is very important. I mean, that's the opportunity for you to basically give your opening statement, to outline the strengths and weaknesses, to give a analysis of what settlement discussions have occurred and why they haven't been productive, to lay out, the issues that you need the mediator to step in on and evaluate or help facilitate a resolution of. And I think that is a persuasive piece. And I think that some people would view that as just some type of informational document. It is not, in my opinion. This is your first opportunity to convince them that, your client is entitled to X. And it needs to be written in that way. Our client is entitled to X because they did these things, and, these are the documents that support that. I see a lot of attorneys write a book, like a novel on, no mediator wants to read your novel. You need to, this is short, sweet, to the point. Like, let's summarize. Like, this is not the time to attach the entire year-long litigation of pleadings. Like, there are some key points. We are about to argue this motion and our likelihood of success is X because of these two key things that are either going to go our way or they're not. Like, that's the summary that needs to be in here. And I think that a huge advantage going into a mediation is putting a lot of time and effort into making that very persuasive. We use a lot of charts. A lot of times, I was just in a mediation not too long ago, and there are a lot of parties involved, and all of the business names were very similar. It was like ABC, ABCD, ABCDE. Like, for whatever reason, they decided to name all these entities, very confusing. And I don't know. It was just a mess. And I was like, for purposes of this statement, we are going to change the names of all the parties to things that relate to, memorable things. So all of these entities were tied to different properties, which were on specific streets. So I'm like, we're going to call this one green, because this relates to this green property. We're going to call this one red, so that, and the mediator was like, this makes so much sense, right? So in the mediation, the mediator starts then using the terms that we put in our document, and the other side, obviously, this is a confidential document, so the other side has not seen the document. And they're like, what are you referring to? And the mediator's like, well, it was so confusing with the names. And then, this side decided to, tie them to these specific things that make them very easy to understand. And they started using the language that we put into the statement. That's what you want. You don't want them to come in confused and there's all, like, you want them to adopt the language, and those words mean a lot. I had another case, I'll just, for an example, where they kept calling a third party who was involved like the fraudster or some kind of negative connotation to this person. And they put it in all their pleadings, and they kept, oh no, it was the whistleblower. That's what they kept calling this person, right? And I was like, we have to change the terminology that we are going to use to refer this person, because that's not helping us, right? So we need to put into this statement, this person is not the whistleblower. We don't know why they keep calling them that. They are a third-party witness. They have this information. We're not going to call them that in this mediation, because that's framing the issue in a way that benefits them. And I want to make that apparent, that is what they're doing. We don't want this to just, people will start using words and not even understand the association that they have with those words. So we want to make this statement persuasive in a way that benefits us. And that, I think, helps the mediator walk into the mediation in a more favorable position to our client. And I think that is an undervalued tactic. I think a lot of people spend 10 minutes on this statement and then just say, we'll see, we'll just talk about it when we get there. I don't think that helps anybody gain an advantage to the mediation. I think that's a key indicator.
And one of the things that I'll kind of go through as we prep the client for a mediation, especially when we're talking about numbers, is I want them to know the numbers, right? But I also want everybody to understand the cadence of the mediation and the cadence and who's speaking and who's not, especially if you have clients and everything involved. You want them to understand like when they should speak and when they shouldn't. But I try to get them to focus on like 3 to 5 central points, and that we will always, like a mantra, kind of go back to, like, we're here for this and this and this, and then lump all of these other extra issues into one of those 3 categories, because I think the client gets very distracted by the minutia of the issue, and the attorney, because there's a lot of different ways to do mediation, but if the parties are there and you have a mediator in the middle, you're really trying to containerize and summarize in a big picture to the mediator what those 3 points are. So if you can get those 3 points across, then when you pull in an ancillary issue, you're like, well, that does fall under, the secondary point that we've always been talking about. And then you have kind of these things that you continue to say in a very consistent manner. Like I do that for testimony as well, but I think it's very helpful in a mediation, because then everybody in the room is kind of like, oh, okay, yeah, these 3 points, right? And if the other side is all distracted by 100 points, then again, you're getting the focus, the attention of the mediator on your issues and maybe not on some of theirs. Cause it's like, you're trying to collect rainwater here. Like, I don't know where you're going with this, but it's not very clear. But I think understanding what the mediator requests and requires at the beginning is important, and understanding that if you have a lawyer involved, that sometimes they will put together too much. Like you might have to help them, even if you're the business owner, understand the 3 main business points, and then you combine them with the legal points, right? Because you could have financial issues and legal issues and all of that, but what are your central kind of concerns, right?
Point. I think that being a business owner and being involved with another person in a business or another couple people for years, there are a lot of issues. It's usually not this one big thing. I mean, there's different personalities, there's lots of decisions that need to be made, there's lots of feelings that you still harbor about decisions that have been made 5 years ago. So I think that your point about, having those key points, like a theme, helps keep things focused, because I think that if you go off onto too many of those tangential issues, it can distract from reaching a resolution on the big ticket items that you're there to resolve.
Well, because even like conceptually, I've talked to mediators that would say, I only do 2-hour mediations at a time. Or, like if I'm going to be talking about the valuation, a 2-hour window for people to ask questions, to go through it, it is still drinking from the fire hose. Like they are still taking in so much information that they're just overloaded at that point, right? But in mediations where we're dealing with that is one piece of it, and we have all these other pieces, it could be an entire day mediation. So even preparing for that level of attention, do you need fuel? Do you need food? Do you need liquids? Do you have the capability to sit in that capacity for that amount of time? Because that puts stresses on the negotiations, right? So understanding what is involved, which kind of, I guess goes into a little bit of like when you're looking for a mediator, and you have a very complex financial matter, I think a lot of it comes down to your specifics. Some people want in person, some people want online, some people want different types of situations. I don't think people understand that these mediation firms that are really coming about, and even if you are a mediator in space, you have other kind of people that are professionals in this mediation space, right? You have the accountants that understand it, you have valuators, you have real estate appraisers, you have you have other attorneys that talk about like the IP and things like that. So it's not just looking for a mediator, it's also maybe looking for what their resources are, or like don't assume that just because they're one person that it's really one person. Like a lot of times the mediators will have staff and they will have other people that they might pull in depending upon the issue. But what are you kind of telling people to look for, and how are you guys kind of unique in that capacity?
Yeah, I think that is a really good point. I mean, a lot of times there are a number of experts that are required to speak to different issues, and there has to be a decision made about whether they need to be there on the day of the mediation, whether they can prepare something in advance that can be submitted to the mediator. And, those logistics can be specific to, the situation that you're in. But, it is good. We use a mediation group here that has a lot of resources. They have It is a group of retired judges from, federal courts, state courts, different states in our area. So, they have people who have decided just about every case under the sun, and, have a lot of good statistics on their mediation success rates, which is something that we look for. So, I think it's just important to have that conversation. I see a lot of people just choose randomly mediators and not put any effort into who is going to be. I think they think that the process is not going to be that effective, so they don't want to invest too much time into it. But I think it's one of those things that the more time you invest into it, the more likely it is to be successful. So I certainly don't look at it that way, and we have had some very favorable resolutions for our clients in mediation. So I think it's just, putting the effort in, and the preparation in, looking into the mediator's credentials and success rates and the resources and, the experts that may be needed and anything else. I think it's just all of that goes to preparation.
Yeah, and I think there's something to be said about, we recently hired a mediator in a case, and it was a very specific mediator that we knew from prior experience could effectively communicate what we needed, right? And it wasn't because like we would control them. It was that they had a way of kind of calming this chaos, right? That other people would all be very defensive, but their way is just beautiful. And I think that in some capacity, the mediator is just a conduit, like the preparation that goes into, and realistically, if you want to containerize any of the costs in this kind of process, especially because, partner disputes, like, who's going to pay for it? Is the company paying for it, or are you individually paying for it, right? When you get involved in the process and you're vetting the people and you're prepping some of the information and you're doing this, what is your hourly rate? Zero? Like, yes, it's a cost benefit of pulling yourself from your business, but the more, like, this is an opportunity for you to put your time and effort into finding something that, like, even fits with you and your partner, right? In the conversation, and then you talk around and say, okay, are they good at business? Have they done this? Have you seen success? What have they done? It's the same type of situation. It's not foolproof, but you can have a little bit more insight into it and understand, from that capacity. So, and I think for the most part, if you're going to go about mediation as a business owner, you have to know that you're going to be part of that process. Like, not from a controlling standpoint, like you're going to dictate it, but you're going to be part of the creativity, if there is to be any, of how something, like, oh, well, we can't just split this all up. It has to be, protect this and protect that and do that. And don't worry about that. And what about the employees? You have that capability to protect all of those interests, but you're going to have to put your time and effort into it as well. And if you just want it to be solved by lawyers and the court, then you go to trial and you let them deal with it. But the mediation is more like, hey, I think if I am a part of this, I think we can get it resolved, right? Because I'm the business owner. I'm the creative person that thinks that they can come up with something. But maybe you should tell us a little bit more about you, your firm, how you handle people, how you deal with people, and how you maybe came about to do mediation. Because we all have a fun story about mediation, but maybe you have a fun one as well.
Yeah, so we have a law firm in Northern Virginia, and I practice in Maryland, DC, and Virginia. We help people build, protect, and resolve disputes concerning their business. 99% of my practice is business divorces. So we handle lots of different situations that business owners face, and I think that what makes us uniquely qualified is, I am a business owner. So, I I get the struggles and the late nights and the commitment and energy that is required to build a business. And, a lot of those things are at stake. And I think the biggest shift that we have to discuss with our client is, they're successful business owners, and what makes this process hard is that there's an emotional aspect to it. If this was just a business decision, it would probably be very easy for them to do. But we appreciate the fact that this is not just about money. It's not just a business decision. There's a relationship that existed before the business that is influencing a lot of what's going on. So, we have to be aware of that. We have to take that into consideration in our conversations. Even if that relationship is beyond repair, it is going to have an effect on our clients. And I think that people like working with us because we have empathy towards that situation and understanding of that aspect of it. There are certainly lots of lawyers who have experience in business and can value things and give you an analysis of what it's worth. But there's, in my opinion, more to it than that. There's another aspect that needs to be weighed. And I started with that. There's an emotional toll that these type of situations take, and you have to be cognizant of that if you got to survive this and be healthy for yourself and your family. So we it's our job to help you through that process. So I have been doing this for over 15 years, and I really love it. I like working with business owners who are brilliant individuals and help them tackle this problem and move on to other successful business ventures. So or just running their business on their own. That's also a very big difficult step that some people have to take. If you start something with other people and are now in a position where you're going to have to do it yourself, I mean, that is a mindset shift as well. So we work with people in all stages of that process and walking them through that and helping them in that transition is really something that's very close to my heart. So that's what we
Well,
enjoy
and
doing.
I think that that is really impressive because that is, if you go into mediation or litigation, or even I went into math because I thought that numbers were more fun than emotions, then you have to be mindful that you can do everything right from a financial aspect and a legal aspect and a mediation aspect, but the emotions could still prevent the settlement. And so I think that you bring up a very valid point that, it's about being unbiased, but it's not about being unemotional or unempathetic. It's about recognizing it. It doesn't mean that we have to go into it, but we can recognize it as a container, as a safe space in order to do some of this. But I also see people that are helping in mediation, lawyers, financial people, that we are that consultant. Like, we are helping you kind of efficiently go through this mediation process in a way that hopefully both parties, come to a favorable decision. But in the long run, you're hiring kind of a consultant to help you in this process. And for the most part, it's a better process than litigation is. It's a little bit more controllable, right? But there's room for all of them. What we've seen is to do a parallel as well. And so you would be doing a litigation strategy and a mediation strategy if you believe that that is what's necessary. So it is getting the right people in the right room to give you your options, to allow you to have those decisions to be made, and to have a say at it. But we appreciate your time. Is there anything else you want to kind of say about mediation that you think, is really amazing? I mean, I talk about it a lot. People kind of get tired of me saying, it's the wave of the future. Like, you need to be a part of it. Like, it's so great. But,
Yeah.
do you have anything more to add? Yeah.
No, I think we've covered it. I do think it is a great process. I think it's very beneficial, and it doesn't solve every problem. Every case is not resolved in mediation. It's certainly not a slam dunk for all cases, but there are some very favorable outcomes that come from mediation, and I'm certainly a huge proponent of trying it, giving it a try. I think it is worth the effort and time involved in going through the process. So if you were to ask me, I would say yes, you should try
Yes.
mediation, no matter what point you're in your case. It can be before a lawsuit is filed, it can be after a trial, while something is on appeal. We have, mediation is at all stages of cases, and have been. I am a huge proponent of it.
Yeah. And I think that the only thing that I'll say about finding somebody to work with, because again, since it's so new, newer from acceptance standpoint, from acceptance, from business owners and courts and all of that, work with somebody who has a process. Because if they have a process, the odds are they've done this for more than just a year or two. They've really cultivated how they can do it well. So I appreciate all your knowledge, and hopefully we'll have you back on to talk more about business divorces and how we do valuations. But we appreciate your time, Margeaux, and they can reach you if they have questions, right? Because you work around
Yes.
the country. It's not just in the East Coast, right?
Yes, we consult on a lot of cases around the country that involve business disputes and business
Yeah.
divorces. So feel free to reach out. I would love, this is my passion, and I'd love to speak with anyone that we can help through this process.
Yeah. And I'd love to say that there are a lot of people out there like you, but there aren't. And so, I really think that this is a space that is going to blossom, and there will be more providers around the country. But for right now, seek out some people that really know what they're doing. And Margeaux, I feel, is one of them. So we appreciate you, and we'll see you soon.